Hi, it's me again, Kevin Sales, your title rep. I solve real estate problems before they happen. Recently, I helped a real estate agent that's a client of mine establish massive rapport with the personal representative from a probate estate. There's two things really involved, and one is going to take up the bulk of this video. First, you have to have empathy. The personal representative, you don't know what they're going through. They may be very close to the decedent. There may be a lot of challenging issues with heirs or beneficiaries or debtors. You don't know what the circumstances are. So, number one, have empathy with the person going through this probate. The second thing, and this is where I come in and this information comes in, is that a lot of times the personal representative is in a position where they feel like they don't know what's going on. I've heard it many times from personal representatives that their agent isn't communicating with them. I've heard that the attorney isn't communicating with them. So one way or another, they feel left out, like they have no clue what's happening. So a crucial part of the puzzle is for you to keep them informed. And so I've given you a couple steps to do that by talking about the phases of the probate. So the first phase is the appointment phase. It's basically when the probate case is filed with the court and they appoint either an executor or an administrator. During this phase, you produce a will, if there is one, or by matters of law, they figure out who's going to be the executor or the administrator of the estate. This usually happens in months 1 and 2, so the first 60 days of the case filing. Now, the important thing here is that whatever those letters say, the court will issue letters testamentary or letters of administration. Those letters are going to be needed to be given to the title company for closing a transaction, because those letters tell what powers are necessary, and from those letters we can determine what other documentation we need. It's kind of like a driver's license. You don't drive till you have your license. Same thing. You don't sign contracts. You don't move forward in the process until you get those letters of testamentary or letters of administration. The next phase of the probate case is called the administration phase. This is the phase where the personal representative is going to search for all debts. They're going to seek out creditors, they're going to seek out debtors, seek out all the assets of the estate, check for the validity of debts. The personal representative may have to liquidate some assets in the estate in order to pay some debts. They're going to resolve all the debtor issues and claims on the estate, as well as resolve all inheritance issues. Depending on the complexity of the probate case, this could be a long process, as I'm sure you can imagine. Typically, it's months 2 through 8 in an average probate case. The last phase is phase 3, or the closing, and this is the phase in which the personal representative gives the final report to the court. They will give an accounting to the court as well, and that goes both to the court and to the beneficiaries. Additionally, this is the phase where they actually distribute some of the assets or the remaining assets in the estate to the beneficiaries based on the will or based on the matters of law. And the last thing they do is they close the case. And this typically happens in months 9 through 12 on a typical 1-year probate. Now, every probate case doesn't last a year, but I'm just using that as kind of an average. So if you have questions, contact me. Remember, if there's a problem in your business, together we can solve it. As always, consult your own legal and tax professionals for advice. To reach me, Kevin Sales, your probate specialist, you can email me at probatetitle@gmail.com or call me at 213-364-3810.